Okay, this is the first in a series of videos on how we are brainwashed in rail worker death investigation reports by the Transportation Safety Board and its rail partners in crime. And in order to understand these brainwashing videos, you should first look at the two videos, parts 1 and 2, on acts, regulations, and rules, because that is the critical background information that you need to understand how we get brainwashed by these government agencies in these reports. So make sure you look at those two videos before looking at the brainwashing videos. Okay, so this slide is basically one of the last slides in part 2 on acts, regulations, and rules, where I show people where this information comes from. The first screen here, the first section on the left, is a section from the Railway Safety Act, and it definitely shows in the Railway Safety Act that anything that in sections 18 and 19, any changes to railway training programs for frontline employees must first absolutely be approved by the Minister of Transportation before field implementation. So I have here the Railway Safety Act. The middle column is CTC Rail 3, or what's also known as SOR 87-150, the Railway Employee Qualification Standards Regulation. Now, acts override regulations and regulations override rules, but the acts and the regulations are the only ones that are really enforceable in court. Rules are not. Now, CTC, that stands for Canadian Transportation Commission. This would have been legislation passed under the Rail Division section, and it was passed in March of 1987. So CTC Rail 3, when you see that reference, that is the same thing as SOR 87-150. SOR stands for Statutory Orders and Regulations. 87 was the year it was passed. 150 was the number of the regulation. And that particular regulation is the Railway Employee Qualification Standards Regulation. That is the regulation which is behind all frontline rail worker training programs. Now, the very last section here, TCO 0-102, those were proposed new rules. Rules are not enforceable really in court. Rules respecting minimum qualification standards. If something does have to do specifically with licensing, that can be enforceable in court, but rules generally are not enforceable in court. They are one of the lower levels of, well, I don't want to necessarily call them laws because they may not be considered actual laws, whereas regulations and acts absolutely are. So the rules here, TCO 0102, proposed new rules respecting minimum qualification standards. If you look at the arrows here, right above my head, you can see that this document was created by the Railway Association of Canada. It was approved in June of 2009, and there was a very important notation added to the cover page of this new proposed rules document, which stated that these rules did not go into effect until the regulation was revoked or repealed, because these rules were supposed to replace SOR 87-150, which is the middle section here, and that never happened. The regulation has never been repealed. It is the law to this day, and so why would you have any reference to rules which never went into effect in a death investigation report years later? Very good question. And the answer, in my opinion, is because they used that document to pull certain key phrases out of it to then help with their story du jour, as I like to call it, or the brainwashing of the public and of all rail families. So we're going to get into all of that, but you're going to see through all these brainwashing videos that this slide is critical because it shows the act, the regulation, and the rules. So there are three different documents, and how they are used in the Transportation Safety Board death investigation reports, and how they manipulate it and go from one to the other to confuse the reader and whatever. It's golden how they do this. So understanding these three different documents is going to be key as we go through these brainwashing videos. Okay, and before we move on here, there's a few other things I want to point out. So under the Railway Safety Act, not only did the minister need to approve any changes that the rail carriers wanted to do to railway employee training programs, but if you look also at the bottom here, the companies also had a duty to consult per the Act, the Railway Safety Act. They had a duty to consult with the unions, for example, on any proposed changes. Now, under the regulation section here in the middle, I want you to notice two things. The date, where under section 5, where it says no railway company shall permit an employee to work as a locomotive engineer, transfer hostler, conductor, or yard foreman unless the employee has qualified for that occupational category in accordance with section 14, which is the section of the regulation which shows the different categories in which they had to be trained in order to be qualified conductors. And it says, in the case of a locomotive engineer, transfer hostler has received a passing mark for on-the-job training in that occupational category. The next critical section here, part 2, this is very important. It says subsection 1 under 5.5 comes into force on July 1st, 1990. So in other words, this was the law that no railway company shall permit an employee to work in their occupational category unless that person has qualified. That has been the law since July 1st, 1990. You're going to see that in the Transportation Safety Board report tied to the death of conductor trainee Jason Clooney, where they reference this particular section of the regulation, section 5, that point 2 has magically disappeared. And they then use the rule to make it look like this was never part of the law, when it has been part of the law, a regulation, since 1990. Now, if you look below here, this is page 9 of the Railway Investigation Report, R13, which is the year 2013. W0260. This was the part of the death investigation report into the death of conductor trainee Jason Clooney that was put out by the Transportation Safety Board. And on page 9 here, you see that they reference a section 19. That is not section 19 of the Railway Safety Act. They completely ignore that, which says that any changes to training programs must be approved by the minister after the rail carriers have consulted with the unions. They completely ignore that and instead provide section 19 of SOR 87-150, the Railway Employee Qualification Standards Regulation, which basically only says, if you look at the bottom section here, that within 90 days after any change is made to an employee training program required by subsection 1, a railway company shall file with the committee or Transport Canada a description of the change. So they make it look like, because the regulation says you only need to do this after the fact within 90 days, and they completely ignore the Railway Safety Act, which says, wait a minute, any proposed changes to railway training programs must be first filed and approved by the Minister of Transportation. The Act overrides the regulation by presenting only this section of the regulation, section 19, and completely ignoring what the Act says, the higher law. The Transportation Safety Board makes it look like any changes that are then discussed in the railway investigation report tied to the death of conductor trainee Jason Clooney surely must have been done in compliance with the law, because the Railway Employee Qualification Standards Regulation only requires that we file a description of the change within 90 days of field implementation. Wrong. The overriding law is the Act. And so you must file with Transport Canada for approval by the Minister of Transportation any new proposed changes to railway employee training programs. You don't just get to implement them and then tell Transport Canada what you did. The Act overrides the regulation, but in the report pertaining to this death, not only do they remove the effective date for the regulation, they also then provide only a copy of a lower law, the regulation, saying that we only need to file it within 90 days. We need to file our changes, a description of those changes with Transport Canada, when the Act overrides. And so this is one of the ways they deceive you. We ignore the Act, but we discuss a regulation that makes it look like all changes we're about to discuss were implemented legally, because we only had to tell Transport Canada about them within 90 days of field implementation. And that is absolutely not how it works. And now if you look also on the last column here pertaining to the rules, this was a document which was created by the Railway Association of Canada because of a 2007 Mac Yard incident at CN Rail outside of Toronto, where it was so obvious, given this incident, that railway employees were not being properly qualified and trained for their jobs. And so then Minister of Transportation John Baird issued a Section 19 order under the Railway Safety Act, telling all rail carriers operating in Canada, all the Class 1 rail carriers, which would include all the US Class 1 rail carriers operating in Canada, that they had to overhaul all their training programs. But this was a rule, a new proposed rule, not a regulation. So the minister was asking the rail carriers to come up with new training programs. We're going to call it a rule, and we're going to try and replace a regulation, which was the middle one here, SOR 87-150, with these new proposed rules. It never went into effect. But what I want you to notice here is not only was the regulation never repealed or revoked, but if you look at the bottom here, the very last little snippet that I have, this comes from Jason Clooney's death investigation report put out by the Transportation Safety Board. And the rules respecting minimum qualification standards, which are also referred to, if you look at this arrow here on the top part of this last column on the right, where it refers to it as TCO-102. That is the name of this new proposed rule respecting minimum qualification standards for railway employees. So you can see at the bottom in the footnote, when they talk about these new proposed rules in that accident report, they now refer to them not as a Railway Association of Canada report, but because it was approved by, I guess, Transport Canada in June of 2009, they now call this a Transport Canada document and refer to it as TCO 102 as far as the name of the new proposed rules. So again, it's a document that was created by the Railway Association of Canada, but which then assumes its, legality, I guess you can use as a term, because it now looks like a Transport Canada document, when in reality, it is a document created by the Railway Association of Canada, which has as its members, it represents about 50 rail carriers operating in Canada, and that includes absolutely all the Class 1 rail carriers in Canada, which would include also the US rail carriers operating in Canada. So again, very critical to know that these new proposed rules was a document created by the Railway Association of Canada, then made to look in this investigation report like it's a Transport Canada document, um, when I think most people would argue it's really not a transport document. It never went into effect. So why would Canada call it a Transport Canada document in this death investigation report? That's a very good question, and I don't think there's a very good answer to that one, other than that's how we can use it for brainwashing of rail families, the public, taxpayers, in what I call garbage railway death investigation reports. We're going to get into a lot more of that. Okay, so as far as the brainwashing, again, you have the regulation, which is SOR 87-150, and the important thing here is that no railway company shall permit any employee to work as a locomotive engineer, transfer hostler, conductor, or yard foreman unless that employee has qualified for that occupational category in accordance with Section 14, which outlines all the categories that they must be qualified in, that they must be trained in, and that law has been in effect since July 1st, 1990. Now, as we go through the Transportation Safety Board accident report, on page 10 here in this middle section, you can see that, again, on June 23rd, 2009, Transport Canada approved the rules respecting minimum qualification standards for railway employees, called the rules. Those were the new proposed rules that never went into effect. They were written by the Railway Association of Canada as a result of the Mackyard incident of 2007, and even though the rules were approved by Transport Canada, the old regulation, SOR 87-150, was never repealed. And so those rules were never in effect. This was a bogus document, in other words. So why would you include anything from this bogus document that never went into effect in a death investigation report years later? And again, folks, in my opinion, that's to help with the brainwashing that goes on in these reports. So they go through and give you a snippet or two here from these new proposed rules that never went into effect, where they say, okay, well, the rules specify in part that no railway company shall permit an employee to work in an occupational category unless that employee has qualified for that. And then they say, notwithstanding the requirement of Section 4.7, an employee undergoing on-the-job training may perform the duties of an occupational category for which they are a trainee under the direction of the job training instructor. Wrong. This rule, 4.8, never went into effect. The employee cannot perform the duties of the occupational category unless they are under the direction of that instructor. So, Section 5, when they tell you that, at the bottom here, they say, under the new rules, conductor trainees would also receive on-the-job training under the direction of a training instructor for the duration of the training period. Note what's really important here, a training instructor. They're making it look like this is a new rule. You're going to see that that was already part of the training program that was on file with Transport Canada per the Railway Investigation Report pertaining to the Mackyard incident. And I'm going to show you that coming up. So they're saying that per the new rules, conductor trainees would also receive on-the-job training under the direction of a training instructor for the duration of the training period. That was already, again, on file with Transport Canada when you look at what the training program supposedly was already in place. So it says, but then they give you this sentence, to date, the regulations remain in force and the new rules do not yet apply, as if these provisions, which were already part of the law under the regulation and under the training programs already on file with Transport Canada, which had not been changed. So we're making it look like, okay, we're going to give you these snippets of rules that never went into effect, and we're going to pretend that these things would have been there had the new rule gone into effect, and then they say the regulation still applies. The reason they're going to tell you the regulation still applies is because then we get into the regulation sections pertaining to the training programs and stuff, but they're going to ignore the act. So we're going to pretend, okay, the rules don't apply, even though what they're suggesting in these rules was already the law. So again, why are they doing this? It's part of their brainwashing, and you're going to see how that works. Okay, so as far as the brainwashing, again, on page 10 of this railway investigation report pertaining to the death of conductor trainee Jason Clooney, they discuss here at the top these new proposed rules, making them look as though they're not in effect yet. And they were in effect, not as a rule, but as a regulation, and as training programs already on file with Transport Canada, as far as what Transport Canada had already approved as far as what was a training program for CN. So then they get into this lower section here on Canadian National Railway Conductor Trainee Program. So they give you a small description here that before 1995, which is when CN and CP went from being crown corporations of the government of Canada to becoming publicly traded on the stock markets, and now we had shareholders and whatever. We were no longer part of the government of Canada. So before 1995, when they were part of the government of Canada, the training program for railway employees used to take 2 years to become a qualified conductor. And so they give a little bit of a description of that. But then after that, they say since 1995, the conductor training program at CN has been progressively shortened. That's because we became a publicly traded company, and now time is money. And so they truly condensed the training program from 2 years to about, 20 weeks. Then they say in 2012, Transport Canada Rail Conference, which is the union, had been involved in making recent changes to the Conductor Intensified Field Training Program, or boot camp, which is only 2 weeks, and the trainer-trainee evaluation process. So whether or not they've been including the unions as the Railway Safety Act requires whenever there's a change, that's a huge issue. Because if the unions were not involved in all the changes that were made to the conductor training program, as we're going to see further on in this report, that would be a huge violation of the Railway Safety Act, sections 18 and 19, which again are not discussed at all in this accident report. We just discuss rules and regulations and give the story du jour to make things look much better for CN Rail and for the government of Canada and Transport Canada, which hasn't been doing its job, I would argue, in decades when it comes to railway employee training programs, and making sure that railway employees are properly qualified according to the law and the regulations. So as we go on here, it says, CN's present accelerated conductor training program is structured as followed. And then what's going to follow here on pages 11 and 12 and whatever is going to be the supposed new training program at CN. But again, the proposed minimum rules at the top here, okay, those were approved on June 23rd, 2009. And that was a Railway Association of Canada document that never went into effect. So why is it even in this investigation report? But then again, at the bottom, you see the footnote here that refers to this not as a Railway Association of Canada report, but as a Transport Canada report, TCO 0-102, Rules Respecting Minimum Qualification Standards for Railway Employees, which never, again, went into effect. So why have this whole section in here on new proposed minimum rules that dates back to, years ago? They were approved in 2009. Jason Clooney, this report came out in 2014, 5 years later. Why are they even discussing this? Stuff that never went into effect. It's all part of the brainwashing, folks, and you're going to see that as we move forward in this report. Okay, so on page 11 of Jason's accident report, you can see here under the third bullet point where they're discussing the training program that was on file basically with Transport Canada. And so the existing training program that had been approved per the Railway Safety Act included bullet point 3 here where it said, instructor notes are also taken to address any shortcomings the trainee may have. There is no specific pass mark for this part of the course. The information is not required to be communicated to the instructor who delivers the next round of training to facilitate future improvements. Okay, so you've got supposedly a training program that requires an instructor to take notes. But as we've seen previously, and as we're going to see again, the training program was supposed to be under the supervision of one instructor for the duration of the training program. And so there would not have been a requirement to communicate to another instructor any shortcomings because it was supposed to be one instructor to one trainee for the duration of the program. And that clearly was not happening. Then if you go down further here, it says, following belt pack training, conductor trainees must accompany qualified conductors. Here they made it plural. It's not plural in what is provided in the previous railway investigation reports and the supposed training program that was already on file with Transport Canada as approved. So why they put an S here? You know, it makes all the difference, folks, when they're trying to brainwash you. Must accompany qualified conductors on a minimum of 45 trips. This was not supposed to be plural. So you need to, you know, one letter can make all the difference when it comes to plural and singular and what the actual training program on file with Transport Canada was supposed to be versus what they were doing at the time when conductor trainee Jason Clooney was killed. Okay, so what I'm providing here is, if you look at the bottom, the source here is the Transportation Safety Board Railway Investigation Report R07T0270, Table 1, page 11, pertaining to the Mackyard incident that resulted in Railway Safety Act Section 19 order being written by then Minister John Baird to overhaul all railway employee training programs. So in this 2007 incident report, I think this came out in 2009. Anyways, this table would represent what they're now trying in Jason's accident report, which came out in 2014, when they're describing the current training programs for conductor trainees. This is where they were getting this information, is based off of the supposedly currently in place training program for conductor trainees. So if you look here again, and you know, these different weeks here where you have classroom instruction, then observation trips. Obviously, you know, your classroom instructor is probably not going to be the same person as the person who goes on the observation trips or who does your belt pack training. So maybe the different sections here, the different blocks have different instructors. But when you get to the trial trips, which is weeks 10 through 14, the minimum of 45 trial trips in yard and road operations under the supervision of an experienced conductor. That is singular, not plural. So when they said in the previous page that I was showing you that conductor trainees must then, you know, work under the supervision of qualified conductors, by giving the sentence the way they did, making trainees plural rather than saying the trainee must then work under the supervision of a qualified conductor. They didn't make it singular like it should have been according to this table for the training program on file with Transport Canada, by making trainees plural, they can then make the word trainers plural. And so that's part of the brainwashing, how you're wording the sentence. If the sentence would have been singular, it would have said the conductor trainee then must do 45 trips under the supervision of an experienced conductor, as is outlined in this table, which is the training program that was supposedly on file with Transport Canada. So again, part of the brainwashing is that type of stuff, how they word their sentences, and just the letter S can make a world of difference, because we can make it all plural when it should have been singular. Now, and if you look here, the qualification test is supposed to be administered by the conductor trainer. Again, that's singular, which would imply that there was only supposed to be one trainer in the field for each conductor trainee for the duration of the training program in the field. And that is clearly not what is happening. But by making, again, in the previous slide or the previous page where I was showing you where they made that plural, they can make it look like it was just perfectly fine and okay to have several trainers for one conductor trainee. And unless that training program change had been filed and approved by the Minister of Transportation, that would have been a violation of the Railway Safety Act sections 18 and 19, which required the changes to training programs to be first filed with Transport Canada and approved by the Minister of Transportation before going into effect in the field. So by only providing, regulations and proposed new rules that never went into effect, we can make it look like CN really wasn't violating a whole bunch of laws, when in fact it very much appears like it was violating the Railway Safety Act and the regulations pertaining to frontline rail worker training programs. Okay, so what I'm providing here is a section again of page 11 from the Railway Investigation Report pertaining to the death of conductor trainee Jason Clooney. And again, you have a continuation here that the Transportation Safety Board is giving you all these bullet points as to what the supposed existing training program on file with Transport Canada at the time of Jason's death was supposed to be. And note here the arrows where under those bullet points it says, for the qualifying trips, CN has no written policies or guidelines in place that specify proximity requirements between the conductor and the trainee while they perform switching operations. Well, that's a lie. And another part of the brainwashing, because here it says, for qualifying trips, CN has no written policies or guidelines. Well, you may not have written policies or guidelines at CN, but you most definitely have SOR 87-150 Section 5, as shown on the right here, which says no railway company shall permit an employee to work as a locomotive engineer, transfer hostler, conductor, or yard foreman unless that employee has qualified for that occupational category. And by definition, a trainee is not qualified. So they shouldn't be off, a half mile to 2/3 of a mile from their supposed supervising conductor, working basically alone, because that would mean they're working as a qualified conductor when they are not qualified conductor. So again, look at the way the sentence is written here. CN has no written policies or guidelines. Well, that's true. They wouldn't need written policies or guidelines pertaining to the proximity, because the law requires that the supervisor be close enough to supervise the employee, the trainee, given the trainee is not, by law, allowed to work in that occupational category unless they have first qualified. And trainees, by definition, are not qualified. So you see here how they're twisting the report, how it's written up Sure, that's true. CN has no written policies or guidelines. Completely irrelevant. The law, the regulation is there to protect rail workers. I could care less what CN's written policies or guidelines, which are not enforceable in court, have to say on this issue. What matters is the law, SOR 87-150, Section 5, which absolutely is enforceable in court. Now, the other point here, conductor trainees are sometimes permitted to perform the duties of a regular crew member without direct supervision. Well, that may be true, but that is an admission, in my opinion, that CN is violating the law when they allow that to happen. And when I ask my child, I go, how often are you guys expected to work alone as conductor trainees? When my child was in the CN Rail conductor trainee program, the answer I was given by my child was, Mom, you don't want to know. Okay, since this video is getting a little bit long, I'm going to cut it off here for part 1 for the brainwashing series. And the lesson is learn to question everything and learn to understand the laws, the acts, the regulations, the rules, the guidelines, whatever that play into all of this, and how just, one letter like an S making something a plural instead of a singular. All of these issues. Learn to understand how the different tricks that are used in order to give the story du jour by the Transportation Safety Board, Transport Canada, the rail carriers, whatever. Again, like, share, and subscribe. And on that, have a great day, and I'll see you on the next one.